This will take just a few minutes. It's going to run through the basics of conservation easements. A lot of people in here are already familiar with that. My definition is what's set forth in front of you is voluntary legal agreement to limit to a qualified entity and a landowner, between a qualified entity and a landowner, to limit development and protect the conservation values. And it always takes me back to my first week in law school in property. It was my favorite class. And we were taught that property is a bundle of sticks. And when you have take that entire bundle of sticks of property and convey it in fee simple, then you just convey the entire bundle of sticks, or you can retain some and convey a leasehold interest or a conservation easement interest. They're typically donated, sometimes sold, or a combination. So the bottom line of what we're talking about is you retain some rights, limited to agricultural, grazing, farm, ranch, hunting, to place a number of households on it. But then you've also given up or stripped off rights for a dense residential project, commercial, industrial, to put a lot of fragmented ranchettes on the property. However, you typically can have a right to divide one or two or three times. And I will say that each individual conservation easement I've heard people say that it can be so individual as your own thumbprint. So all these different limited rights, and Thomas and Allison will get into more of the retained rights. It's really important that they're a flexible tool. Obviously, the benefits that it allows the landowner to maintain ownership while protecting the land in perpetuity, and these income and estate tax benefits that will be covered later. And again, the flexibility in my mind is the key. Continuing on the basics, the tax savings for conservation easement donations, there's basically three. There's an income tax deduction when donated, lower appraised value of the land in the state, and they can exclude part of the value of the land from the estate, and that'll be covered in depth. And everybody knows that the fiscal cliff basically enhanced them. Extended the enhanced tax treatment through the end of this year. There are a couple of different primary statutory authority for conservation easements in state law, as well as federal law. The federal law basically, the state law requirements basically generally follow the federal law. So we'll kind of jump in and hone in on the federal law requirements. And there are three of them. I think of them as a three-legged tool to the basic federal law requirements for federal income and estate tax breaks. One is a qualified real property interest. That's another phrase for a conservation easement. Granted in perpetuity, and then granted to a qualified organization and granted for a conservation purpose. And we're going to drill down on the second of those two prongs right now. First, granted to a qualified organization, nonprofit conservation organization, land trust, national to local. That's everything from international, the Nature Conservancy, to all the landowners and land trust, in this room today that we're all very familiar with. And another type of qualified organization is a governmental agency with conservation mission and policies, federal to local political subdivision. Again, we're talking about things like in this county, Travis County's BCC program, San Antonio, Bexar County, Edwards Aquifer program are other examples. This other prong, granted for conservation purposes, we'll spend a little bit of time to drill down on that. Remember that it's basically one of four following purposes that you have to meet, and that again is one of the four following. Outdoor recreation or education of the general public. And so there you're talking about a nature trail or Boy Scouts or somebody being able to access it. And the regs talk about substantial or regular use by the public. And so obviously if you're looking at 365 days out of the year access to the public, that meets that requirement. Or what if it's just 1 week? It's kind of a question of degree. The better you're more apt to qualify under that prong, the more the public access is allowed. The second is protecting a relatively natural habitat of fish, wildlife, plants, or similar ecosystems. And relative to natural habitat, it doesn't mean, not untouched land, not untouched habitat. If it's got rare species and natural areas that are ecologically viable. The way I think of it as basically any significant size property, there's a good chance that it would qualify under that particular prong. The third is the open space, and this can be farm and this can be farm and forest land as well. For scenic enjoyment or government policy, and there has to be a visual access. That visual access is not physical access. It's preserving basically unique land in the public view. The regs talk about land that can be protected between the ocean and the highway. That meets that test, so there's obviously an important aspect to that. You don't want to allow your building envelopes to be going in that area. You may wind up disqualifying yourself for that. And then the final one is historically important land area certified historic structure. To me, there are three prongs to the successful land conservation. Obviously, everybody knows about the land, but we'll talk a little bit more about first the landowner and then the land trust. In my mind, really one of the keys is when I visit with a landowner to consult for the first time is just to really figure out what their motivations are. Many of them are conservation minded, and that's really what they want to do. But obviously the tax benefits are significant, and oftentimes there's development pressure and a desire to be able to keep the land in the family. And it's important, I think, for the land trust and everybody involved in the process to get to know that landowner, the history of the land, what they'd like to see happen to the land, what their conservation values and intentions are. And it's really goes back to what I said earlier. You get to call the shots about what you do, agree to do in a conservation easement or not. And so it's important to really drill to the bottom of the well of that. I think people oftentimes kind of skip over that. But similarly, land trusts, everybody knows what they are and what they do, and here's some websites if you want some good information for that. Primary responsibilities of enforcing the restrictions and monitoring the property is a big deal as well. But I think it's real important for the land trust when you consider which is going to be the good match. Obviously, organizational agency capacity, availability of funding, project criteria, but to me, it's the whole thing it comes down to is the mission of that land trust. As Thomas was talking about earlier, working with the Conservation Bank, there may be a really great land trust that has an in-depth understanding of protecting water quality or open space, but doesn't have a clue what to do, what the Fish and Wildlife Service is going to require to manage golden cheek warble habitat that somebody's trying to impose a conservation easement on. So it's really important to find that land trust that understands the appropriate mission and values that you're trying to accomplish. And it's a partnership. It's really key. Here are the primary major steps for a conservation easement, from the site visit to the appraisal, the survey. To my mind, the legal drafting of the easement and the baseline documentation are the huge kind of time sucks out of that you really need to have some advanced planning and some advanced lead time to get those going. I started out as a real estate transactional attorney and started getting brought into things, conservation acquisitions. And what I tell people in my mind, conservation easements are the most sophisticated real estate transaction there can be, because there are so many other third-party consultants that are involved, and you got to meet the IRS regulations, and it's a pretty important, significant deal. I always get the question, how long does it take to do a conservation easement soup to nuts? And it's really hard for a private conservation easement, or a public one that involves federal funding or public funding of some sort. It's really hard to predict. I just kind of, as a general rule, say 3 to 6 months for private conservation easements. If there are public dollars involved, it's significantly longer than that. I was trying to think when I was in the audience, I did a 3,000 and 11,000 acre conservation easement that had to be done by the end of last year. And I think that the landowners pulled the trigger on that around October. and that was just almost, you know, is a minor miracle that we pulled it off. You know, I canceled all my holiday plans, and a lot of people did to get that accomplished. But part of it was we had a real nimble land trust that we worked with, and we had really good consultants, really good baseline documentation folks. Oh, and speaking of baseline documentation, obviously that's important to have detailed evidence. The conservation values, IRS requires it, and it's from a land trust standpoint, provides you a good summary file for your organizational year, so you can go back 20 years from now and understand what the intent of the parties were. You know, was in fact there this improvement, this structure that's now on the property, was it back there on the property back then? So with that, I think we'll go to a break, and I appreciate your attention.